Over the past few weeks, we've thought about the different elements that make up a contract, so offer, acceptance, consideration, and the intention to create legal relations, but we haven't thought too carefully about what actually goes into a contract. We can't really be too specific on this point because obviously contracts can vary wildly from one to another, depending on what the parties want to achieve. The contract for buying a horse is going to look very different from the contract of employment for an individual person. However, in a general sense, we can think about the terms of a contract and what actually makes up the contract. In future weeks, we'll look at implied terms, but for the time being, we're just going to be looking at express terms. In other words, the things which are said and written down by the parties. So with that in mind, let's get started.
We know that there are both oral contracts and written contracts, and what the terms look like in each of those situations is going to be quite different. In the context of oral contracts, there isn't going to be anything written down that the courts can look at or rely upon, and so the judge is going to have to rely on the evidence that is presented by each of the parties in that situation. Written contracts are obviously a lot easier because there is a physical contract document that the courts are able to look at. It's important to note that the courts are going to look objectively at this document, and so they're not going to rely on outside evidence from the parties that says, oh, this word should be interpreted in this particular way. And that's something that's called the parole evidence rule, the idea that the written contractual document should be looked at objectively from the perspective of a reasonable man. This parole evidence rule can seem a little bit harsh and means that no other evidence can actually be introduced to the contract, but there are some exceptions that do allow for a little bit of flexibility, in particular where the contract is both written and oral. Often students will tend to think of contracts as either being written or being oral, but it is possible that there is a sort of hybrid between those two, and later on we'll come back to the idea of collateral contracts, and that can sort of feed into this idea that we have written and oral contracts that can work together. Furthermore, if evidence provides use of a custom or a trade usage, then that can also be an exception to the parole evidence rule. If the contract is yet to take legal effect, whether that's because a certain date hasn't come around yet, or more likely that a certain event hasn't happened yet, then that is again something that the courts can rely on, and we have Pym and Campbell for that particular case. And the parole evidence rule has an exception in the forms of cases of common mistake as well. In other words, a mistake that is made by both of the parties, but mistake is something that we'll come back to in a future lecture. The other part of this idea is that it's an objective test that we have, and Lord Steyn goes into this further and tries to delve into what it actually means to have an objective test that just looks at the contractual document, and says that the question is what a reasonable person, circumstanced as the actual parties were, would have understood the parties to have meant by the use of specific language. The answer to that question is to be gathered from the text under consideration and its relative contextual scene. So let's get into this a little bit further, meaning that when we look at the contract, it actually means looking at it within the context of a commercial practice within a given sector. And what we mean by this is that different contracts are going to have different certain meanings depending on what business you're in. If you're involved in shipping, then a shipping contract is obviously going to have very different terms and different interpretations compared to, say, if you were selling a house. Furthermore, the case of the Starson from 2003 tells us that if there's a discrepancy between the main text of a contract and the small print, then it's going to be the main text that takes precedence. Again, this was a shipping contract where the main terms were written on the front of the document, and then there was some fine print towards the back. Now, when these two collided and there was a discrepancy between the two, it was the main terms of the contract that took precedence. However, if there is little or no commercial context, then the courts are going to take a more literal approach to the wording of terms. This case comes from the recent 2015 case of Arnold and Brighton, which was to do with maintenance and repairs on holiday homes, and there wasn't really any precedence in this area, and so the courts took quite a more literal interpretation, much to the detriment of one of the parties in that particular case. One of the other things that can come up in the context of express terms is whether we're actually looking at terms of the contract, or whether they're merely representations or just talking between the parties. This is quite easy to imagine because obviously contracts are often preceded by negotiations, and so there's a bit of a question during that negotiation stage about whether what the parties said is actually part of the contract, or whether it's just part of the sort of general chit-chat of negotiations. So the idea of this chart here is how easy it is for the parties to be held legally liable for each of the different things. At the top we have terms, and the terms of the contracts create a legal obligation between the parties, and so it's very easy for one of the parties to sue another if they breach the terms. On the other hand, we have fraudulent misrepresentations and negligent misrepresentations, which, although they're not terms of the contract, they can actually be sued upon, although we'll look at those in the context of another lecture. Finally, at the bottom we have innocent misrepresentations, which is the idea of a representation that's made by a party which is neither fraudulent or negligent, and so it's not really possible for a party to sue on it. So the real question here is, how can we actually tell the difference between what forms a term of the contract and what is actually just a representation? Well, we can use a number of factors to tell the difference. Firstly, was the representation a part of the contract or simply a part of the preliminary negotiations? And we have a couple of cases that I think it's worth going into the facts of a little bit just to sort of get into it. So Bannerman and White, the situation was that someone was buying hops and they didn't want hops that had been treated with sulphur. Hops, if you don't know, are often used in the making of beer and lager, so that's the context for that. And obviously you wouldn't want hops that have been treated with sulphur in that particular context. The buyer in this situation said that if they had been treated with sulphur, then they wouldn't be interested in buying the hops whatsoever. So the seller said, yes, it's fine, they haven't been treated with sulphur, but you know what happens, it turns out they had. And so the buyer tried to sue on the contract. And they said, the court in this situation said that because the buyer in this situation, as part of those negotiations, had said that and made it very clear that they wouldn't be interested in buying the hops unless they had not been treated with sulphur, that was such an emphatic description that it would form a part of the contract that the hops had not been treated with sulphur. However, it can also be part of preliminary negotiations, so Routledge and Mackay was about the buying of a motorcycle, and as part of the previous discussions before the sale went ahead, there was a bit of a question about what year the motorbike had been made and what model it was. Someone had said 1930, another had said 1942, and it turned out that it was sort of 1942. But it wasn't essential to the contract, and so therefore it was considered that this was just a representation because it wasn't something that the buyer was relying on when they actually made the purchase. The second factor that we can look at, which is not an essential one, is putting a representation down in writing does generally indicate an intention to be bound, and so the written form is obviously going to be more emphatic than the oral form. That's not necessarily essential. Birch and Paramount Estates, someone was shown a show home as an example, and they said, will the other homes be as good as this? And the answer to that was yes, all of the homes on this estate are going to be the same. And so when it actually came down to it and the house was not of sufficient quality, even though that wasn't a written term of the contract, that part of the negotiations actually formed a part of the contract according to the courts. The final factor that we can look at to distinguish between a term and a representation is whether the representor had special knowledge or expertise, and if that is the case, then their statements are more likely to be considered a part of the contract. In the case of Harding and Eddy, the seller was trying to sell a cow at an auction, and there was a bit of concern amongst the buyers because the cow didn't look especially healthy. Nevertheless, the seller reassured the buyers and basically said, yes, it'll be absolutely fine, don't worry about it, the cow is just doing perfectly fine, thank you very much. Now, of course, the person who bought the cow then took it home, and the cow died a short while later because it turned out to have tuberculosis. Now, when the buyer then tried to sell on the contract, one of the factors that was taken into account was that the seller in that situation had special expertise and knowledge about the health of his own cow, and so making that representation about its health could be seen to actually be forming part of the contract. Finally, before we finish up, I think it's worth making a brief point about collateral contracts, and this is the idea that we can have a situation where a representation is a collateral contract that is separate but then linked into the main contract. City and Westminster Properties can hopefully help me out and try and explain a little bit more what I mean by this. The tenancy agreement for a particular attic space that was often used for sort of offices or a workshop had a part of the contract which basically said that the office space had to be used for that, and people weren't allowed to sleep in that particular area. Now, Mudd entered into a contract, but it was well known that he had been sleeping in this area for a long time, and he just slept as part of his office and where he worked, and so that was well known to both of the parties. When it came up for the tenancy renewal, he was obviously a little bit concerned about this new term about not being able to sleep there. And so what the council did, what the property company did in that situation was that they said, oh, don't worry about it, we will ignore that particular clause of the contract. And so Mudd entered into the contract on the basis that that clause wouldn't be enforced. Of course, what then happened was that there was an attempt to enforce the clause because Mudd was sleeping in the property. And so it was held that there was a separate collateral contract where basically Mudd said, I promise that I will enter into the main tenancy agreement if you don't enforce this clause. And so that links but is not part of the main contract, which is the tenancy agreement between the property company and Mudd. So we kind of in that situation have two contracts which are separate, but they're linked. And so that is the idea of a collateral contract, which can be oral and then written.
So that covers express terms in contract law. Hopefully, if this comes up as part of, say, a problem question, the terms of the contract will be relatively easy to identify. Nevertheless, it's important that you do point them out. If they are a bit difficult to identify, then this is actually an opportunity for you to go through some of the tests that we've mentioned during the course of this lecture. In future weeks, we'll also go on to look at implied terms, but for now, if you enjoyed this video, make sure to leave it a like and subscribe as well. If you have any questions, leave those in the comments below. I'll be back with another lecture in the future, but for now, bye!